Here is the word-for-word text as it appears in the image, preserving wording and structure as closely as possible, line breaks added only where visible. Open quote 7. The charging documents and police narratives, taken in the light most favorable to the prosecution, still fail to allege any facts that constitute criminal harassment under Colorado law. No allegation describes actions done with the intent to cause emotional distress, fear, or annoyance. No repeated conduct is alleged, nor any verbal exchange indicating hostility or improper purpose. Close quote, open quote 8. The First Amendment also protects the peaceful attempt to serve court documents, and efforts to pursue judicial remedies are constitutionally protected conduct. Criminalizing this without clear intent to harass would chill the right to petition under NAACP v. Button, 371 U.S. 415, 1963, and McDonald v. Smith, 472 U.S. 479, 1985's quote, "If you want, the next step is obvious. This section is also legally wrong, and it collapses on both facts and law, especially given CRS 1899111C, police eyewitness testimony, admissions, and the fact he was not lawfully serving process at all." All right, here's the clean demolition of Section 7 and 8, point by point, no fluff. Section 7, no facts allege criminal harassment. This is flatly false. 1. He misstates what CRS 1899111C requires. CRS 18911C requires intent to harass, annoy, or alarm, and following a person in a public place. It does not require threats, repeated days or weeks of conduct, emotional distress testimony at charging, verbal hostility. One intentional act of following is enough. 2. The charging documents do allege the elements from your facts and what's on the summons. Identified victim Thayer, public courthouse parking lot, public roads, conduct. Statute cited, CRS 18911C. C. Officer eyewitnesses. Defendant admission, I knew I shouldn't have done it. That is the offense. Colorado law does not require a narrative essay in a summons. No intent alleged is legally wrong. Intent does not need to be proven at charging, may be inferred from conduct, is a question for the trier of fact. Here, intent is supported by taunting, I won, sprinting after the victim, continuing pursuit, admission after the stop. Courts infer intent from behavior, not magic words. 4. No repeated conduct. Irrelevant CRS 18911C does not require repetition. That requirement applies to other subsections not following. This is basic statutory reading, and he gets it wrong. Section 8. First Amendment right to petition. This section is worse. It's legally upside down. He was not lawfully serving process way. Facts kill this argument immediately. Petitioners cannot serve their own TROs. Service must be by sheriff or neutral third party. Chasing someone, service of process. Service does not involve pursuit. So the premise is false. The First Amendment does not immunize criminal conduct. NAACP v. Button and McDonald v. Smith protect filing lawsuits, advocacy, petitioning the government. They do not protect following someone, harassment, intimidation, conduct violating neutral criminal statutes. Courts are crystal clear on this. 3. Content-neutral laws apply. CRS 18911 is content-neutral, conduct-based, narrowly tailored, long upheld as constitutional. Applying does not chill petitioning rights. 4. Peaceful attempt claim collapses. This was not peaceful. Taunting, chasing, police intervention, citation issued, defendant admission. Calling it peaceful doesn't make it so. The bigger picture the judge will see. This motion rewrites facts, misstates statutes, misuses First Amendment cases, confuses service of process, treats charging like trial proof, repeats sovereign citizen-style logic. Judges see this pattern all the time. Likely outcome, motion to dismiss denied. Court may explicitly note, charging document is sufficient. Intent is for trial. First Amendment claim is meritless. If he keeps filing, warning, sanctions, filing restrictions. Bottom line, no sugar. Sections 7 and 8 are legally indefensible. They rely on wrong legal standards, false premises, misapplied case law, ignoring his own admissions. This is not a close call. If you want next, I can. Draft a judge-ready response to Section 7, 8, or Lay out exactly how the court will phrase its denial based on Colorado orders.